After a long wait, the Independent National Electoral Commission on Wednesday last week declared the presidential candidate of All Progressives Congress, Bola Tinubu, as the winner of the 2023 presidential election. Chairman of the commission, Mahmood Yakubu, made the announcement in Abuja at exactly 10 minutes after 4 in the morning. The former Lagos State Governor polled a total of 8,794,726 votes to defeat his closest rival and presidential candidate of the People's Democratic Party, Atiku Abubakar, who scored 6,984,520 votes, while Peter Obi of the Labour Party registered a total of 6,101,533 votes. Rabiu Kwankwanso of New Nigeria People's Party came a distant fourth with a total of 1,496,687 votes. The president-elect Bola Tinubu called for unity and collaboration with those who lost out in the contest. The former Lagos State Governor thanked all those who participated in the February 25 election, with particular mention of articulated, obedience, Batified, and Kwankwansia supporters. The Labour Party presidential candidate Peter Obi says he will challenge the Saturday, February 25 election in court because he actually won the contest. The candidate of the governing All Progressives Congress, Bola Tinubu, has been declared the winner. But Obi says he will prove that his mandate was stolen. Arise correspondent Omo Bazuaye reports.
All eyes had been on the presidential candidate of Labour Party, Peter Obi, since the presidential election last Saturday. No words about the election had directly come from him regarding the outcome, and his silence was beginning to trouble a few, especially his supporters. Labour Party had on a number of occasions rejected the outcome of the election, but many still wanted to hear from the man, Obi himself.
This election, as you know, did not meet the minimum standard expected of a free, transparent, credible, fair election. It will go down as one of the most controversial elections ever conducted in Nigeria. And I assure you that good people of Nigeria that will explore all legal and peaceful action to reclaim our mandate. We won the election, and we will prove it to Nigerians.
The Labour Party presidential candidate says he's determined to drive the process to a logical conclusion and that he has confidence in the judiciary to retrieve his mandate. The former governor of Anambra State also states that he is not in any form of alliance with the People's Democratic Party, PDP, nor under any form of pressure not to restore his victory. Obi polled a total of 6,101.533 million votes to come third in the elections, a result he and those with him in the Labour Party consider at best a daylight robbery. Omo Bazwaye, Arise News.
In the same vein, the presidential candidate of the People's Democratic Party, Atiku Abubakar, has also rejected the presidential election results, saying the poll has gone down as the worst in the history of elections in Nigeria. The former vice president is determined to challenge the outcome in court and also argued that Peter Obi, the Labour Party standard bearer, could not have won the presidential election, having failed to achieve the constitutionally required spread needed to be declared president.
Preliminary assessments indicate that it is the worst conducted election since the return to democratic rule. The manipulation and fraud that attended this election was unprecedented in the history of our nation. I can still not understand why the electoral umpire was in such a hurry to conclude collation and announcement of the results, given the number of complaints and irregularities of bypassing of the beavers, failure of uploading to the IRV, and unprecedented cancellations and disfranchisement of millions of voters in breach of the Electoral Act and the Commission's own guidelines. It was indeed a rape of democracy. Having consulted with leaders of our party who are seated here with me and Nigerians from different walks of life, I have come to the conclusion that the processes and outcome of the Presidential and National Assembly elections of last Saturday was grossly flawed in every material particular, and as such must be challenged by all of us.
Still on that matter, 7 states in Nigeria have withdrawn a suit they filed at the Supreme Court challenging the declaration of Bola Tinubu as a winner of the February 25th presidential election. The states, including Adamawa, Akwa Ibom, Bayelsa, Delta, Edo, and Sokoto, had dragged the federal government before the apex court over perceived irregularities in the conduct, collation, and announcement of the results of the presidential and National Assembly elections. The states also sought, and I quote, a declaration that the fundamentally flawed electoral process through the non-uploading of the results of each of the 176,974 polling units nationwide in respect of the presidential election and National Assembly elections contravened the relevant sections of the Electoral Act 2022. In addition, they sought a declaration that the failure of the federal government of Nigeria and the Independent National Electoral Commission to electronically transmit or transfer polling unit results violated the relevant sections of the Electoral Act 2022 as amended. The latest development, the Court of Appeal in Abuja has acceded to request by Atiku Abubakar and Peter Obi to inspect electoral materials used in the conduct of the presidential election. The 2 presidential candidates who were pronounced second and third behind now President-elect Bola Tinubu have alleged a grossly flawed election, and both have commenced their separate legal actions to challenge the outcome of the election at the Court of Appeal, which acts as the Presidential Election Petition Court, where the outcome of any presidential election can be challenged by aggrieved candidates. They have both filed separate ex parte applications praying to be granted access to inspect sensitive materials used for the conduct of the presidential election. In pursuit of a clearer understanding of these developments and some invaluable professional perspective, we now turn to Chief Robert Clark, Senior Advocate of Nigeria, a lawyer and elder statesman. Great to have you, sir, on This Day Live, the Sunday talk show.
Always my pleasure.
Well, Chief Clark, let me ask you, will you say that they just concluded National Assembly and presidential elections of February 25, in your own estimation, met the expectations of Nigerians? If not, why?
Well, to be very, very honest, it depends on which divide you are. Nigerian politics has sharp divisions, and whichever divide one is, one may be tempted, to tilt towards that. But speaking for myself, there is always a presumption in law, especially in the law of evidence, that during the operation of undertaking an election is deemed in law to be correct. It is a presumption that is rebuttable. Therefore, when it goes to the tribunal, there is this presumption that INEC has done the correct thing. I've always argued against this law, that it places a burden on a respondent in an election petition and places that respondent in a very difficult position to win any election matter. It is difficult to win any election matter in Nigeria. I've been involved in election matters for almost 35, 40 years, and it's difficult to win an election petition because of this presumption that INEC has done the correct thing. So if the law says INEC has performed as a public officer, and there's a presumption that what it has done is correct. Who am I if I don't see any other information that can change that notion? So as far as I'm concerned, INEC has done its best.
Well, there is yet another presumption, and this is in the public domain, which is that in an election matter of this nature, there's no way the court can do justice. That once you win an election at the presidential level, well, whoever wants to complain can go to the court. The pattern in Nigeria has shown that the court will uphold the outcome in any case. Do you share that view?
Dr. Bati, tell me how many election petitions have been won in Nigeria. Tell me. You remember 8 years ago, I was in your studio on this Atiku's case, and you asked me the question, if I were Atiku's lawyer, what will I advise? I told you, don't go to the Supreme Court because you will lose. The evidence available in the lower court is not sufficient enough for you to win. Therefore, all depends on the evidence before the court. If there is strong evidence, if there is a technical rule that to be accepted, well and good. But until the facts are before the domain of the public, one has to go by that principle of law that INEC has performed creditably. Now, in the public opinion, it depends also what facts are within the knowledge of each political party. I am not a politician. I was not on the field. So I'm not aware of many of the allegations being made by the political parties. But when such allegations are brought before public domain, then I'll be in a better position to see and be able to judge on those facts. But as of now, I am limited. And the presumptive fact that INEC has done correctly.
Well, there's been a lot of controversy over the correct interpretation of Section 134, sub 2, with regard to the qualification, for someone to become president. And the major issue is whether a quota in 2/3 of the states will include the Federal Capital Territory, Abuja. Some senior advocates of Nigeria have said, oh, it includes Abuja. The most recent intervention being that of former Attorney General of the Federation, Abubakar, who said that in the Muhammadu Buhari versus INEC 1988 case, that was the decision of the court. But it has also been pointed out that Abubakar was referring to Section 146 of the Constitution, not 134, and that his interpretation of the holding in that particular case is wrong. But should the phrase "and" should it be read conjunctively or disjunctively? This is the question, that is out there.
Well, fortunately, your first question was qualification. I don't need to say much about that because the courts in Nigeria for years have ruled on that. And it's clear, to everybody in Nigeria what constitutes minimum qualification to be, elected. The second question is the most serious question. In 1979, during the Shagari case, I was privileged to be a junior lawyer to late Fani Kayode. And the question of 12-2 came up. The same thing has come up this year, what many people have not realized. When 12-2 was the issue in 1979, as a committee to look into what constitutes 12 thoughts of 19. The late Akinjide, who was the legal advisor to NPN, called a meeting, and I followed Fani Kayode to that meeting. At that meeting, Akinjide told us, oh, gentlemen, I have got an answer to 12-2. So Fani Kayode said, well, if you have already got an answer to 12-2, why did you call this meeting? So he said, Robert, I said, sir, pack the books. So we moved out from the meeting. But unfortunately, I had seen an answer to 12 tutors. I saw some Australian cases under taxation where the law says if there is a statute that provides you to do certain things or to do certain obligations, and such an obligation cannot be identified, then the court will not ask you to perform a higher burden but a lower burden. If you ask a secondary school boy, what is 12, 2/3 of 19, he will say no. If you ask him, is 13 2/3 of 19, he will say no. So neither 12 or 13 was 2/3 of 19. So when you get to the court will not ask you to perform a higher burden, which is 13, but will ask you to perform a lower burden, which is 12. It's a taxation matter. Now, today in Nigeria, Abuja has been added to the state. Yes.
Please go ahead, sir.
Look, I'm on air. Hello?
Please go ahead, sir.
Listen to me, Dr. Abaji.
I'm listening.
Look, today in Nigeria, we have agreed that Abuja is part of the states. And the law states any candidate must have tutors, not only of 36 states now, but 37 states. What is 2/3 of 37? Arithmetically, you cannot get it. So we are in the same position that we were in 1979. My observation is this. The Supreme Court has on different periods claimed that in accepting Abuja as part of the state of Nigeria, it must not be granted any undue privilege. Therefore, if that section of the provision says to come under the doctrine of 2/3, Abuja is part of the states. That does not mean in joining Abuja to the other 36 states, it should now enjoy a special privilege. Therefore, we now have 37 states. So my own view, my own considered view, is that Abuja is part of the 37 states, but sits on that 37 states as one of the states. It does not occupy any unique role more than being part of the 37 states. Therefore, when deciding whether a candidate thirds of 37 states, Abuja will count just as one state, but not with any special privileges attached to it.
Okay, if I could...
That is my view.
Yes, if I could break that down. The controversy is that the president-elect, Bola Ahmed Tinubu, scored 18.8% in the Federal Capital Territory. What I understand you to be saying is that it doesn't matter. It doesn't need to get 25% of the votes in the Federal Capital Territory because that will amount to giving the Federal Capital Territory the powers of a veto over the remaining states of the Federation.
Definitely. If Bola Tinubu had won 25% all that and fails to get 25% in Abuja, where is the equity in throwing him out? Therefore, that is why the Supreme Court is saying, Boris case. There are many cases. Let the lawyers go and do research. These young lawyers, they don't work. When you do the research, Supreme Court says, look, we admit Abuja as a state, status of a state, but do not please attach any privilege to that. So that what a state is required to do, Abuja too is required to do. But to isolate Abuja as a special state, no. The Constitution did not envisage that.
Well, Chief, I assume that you voted on February 25. What's your assessment of INEC's performance beyond the presumption in the eyes of the law that INEC has done very well? What's your own personal assessment?
Dr. Abba, Dr. Abati, I'm 85 years old. I don't go out to vote again. Yeah, so I never left the precincts of my house. I was eating fine amala and the egusi soup or whatever soup. I never voted. But I'm telling you that the law says there is what do you call it?
The presumption.
Of irregularity attached to a public document. When a public document is tendered in court, there is a presumption of regularity attached to it. That presumption is rebuttable. So by the law of this country, by the rules of the law of evidence, whatever INEC produces in court, there is a presumption of regularity attached to it. I have criticized it so many times, that section of the law being attributed to INEC. I said, look, change this law. You are giving INEC an undue advantage. Let INEC first come before the tribunal. This is the work I did, and I did it perfectly. I did this. But now, you have attached this very high, on INEC. INEC does not need to go to election petition in Nigeria, as the law is. They don't need, because the law has already said that there's a presumption of correctness in what they did. That is the difficulty we have in this country.
What do you think of the 7 states of the Federation that went straight to the Supreme Court to question the INEC process, the electoral process, and then, of course, eventually discontinued the matter.
That was
and said they will go to the tribunal.
That is a non-starter. You see, at times one has to keep quiet. At times one has to talk. But I don't know which lawyers decided to sit with the attorney generals of these states and decided to go to Supreme Court on an election matter. When it is clear from the law of Nigeria that any matter relating to election matter goes to a tribunal, how can attorney generals of this state sit down? But I don't blame them. It's not their money. It's not their hard-earned money. It's a non-starter. It is wrong, but I'm happy they've withdrawn it. I'm happy.
Okay, Chief, it's been observed that voter turnout in this election has been the lowest of all presidential elections since 1999, 27% voter turnout. If you add up all the figures announced, just very few, very low figures, just about 25, 26 million. And if you look at the percentage, the margin with which the presidential candidate, the president-elect won, 8.8% out of a total of 93.5 registered voters. Does that raise any issue of legitimacy or credibility?
I have to state this. The circumstances under which the 2023 elections were held has its peculiarity, which has never happened in Nigeria elections. Since 1999, we've had about 7 elections. Okay, tell me which one of the previous elections had the scarcity of petrol, the scarcity of money. Look, Dr. Abati, presidential elections, it's not child's play. You need money. There are about 101,700 and something polling stations. These political parties have to put, by law, in order to sign from EC8 or whatever, you have to pay them. To run a political party. You see, we created the problem. We do not allow independent candidates. We say that anybody who wants to be somebody in Nigeria must join a political party. Why? Why is that? If I want to be president of Nigeria today, I must go and join a political party. And I don't believe in them, so I have to sit at home. There are many things wrong with us in Nigeria today. And now, once you make a political party the dominant party, they have to organize themselves. They have to have their returning officers at the ward level. They have to pay them. And that is the time you, the central bank, says currencies must not float. Look, the things that happened in this election has never happened in Nigeria. So what happened is that I have about 4 or 5 of my boys. They couldn't go to vote because they had no money to even take Okada. So this voting, you have to look at all the circumstances of the case. If things were normal in Nigeria during that period, people would have gone out to vote. But you don't know how people suffered during this period. Because you people like Dr. Abachi, you are the elite in the society. So you never suffered. You had an official car to carry you. But the poor people in Nigeria who are eager to go and vote, they could not even leave the house because there was no money. So the circumstances during this election did not permit for people to rush to go and vote. So that's one of the main reasons why there was a low turnout. I can assure you that.
Well, Chief, what would be your advice to Mr. Peter Obi of the Labour Party, Waziri Atiku Abubakar of the PDP, and Senator Rabiu Musa Kwankwanso of the NMPP, who have all said that they are going to court, and they've already gone to court? Will you advise them not to bother, that the battle is won and lost?
Dr. Abati, at my age now, I don't give opinions for free. I'm looking for money to maintain life now and enjoy myself. So if any political party wants me to advise, because I can, look, the benefit of my experience, I'm not boasting. In Nigeria today, in election matters, I was Shagari's lawyer. I was the sole counsel to NRC. When Nigeria was 21 states, I am the only lawyer in Nigeria that has traversed any court in any of the states. If any political party wants my advice, let them come and meet me. And I'll give my public opinion, but not to give a public opinion that is not fetching me kobo. So you are in a position to, seek for my advice on their behalf and tell me how much you can pay me as consultation fees.
Well, Chief, we have another election. Governorship and state houses of assembly on Saturday, March 11. What are those lessons that you think that Nigerians should have learned from the February 25 elections as we move towards another general election on March 11?
Number one, if the great federal government releases money according to the Supreme Court judgment and money flows out, then the circumstances will have changed and people will be ready to go out to vote. Now, my advice is that if the situation is normal and I have money to take my Okada or anything, I will advise everybody to go and vote because we are in a very crucial time in Nigerian history. There are many things wrong in this country. But the Nigerian Constitution, as I said, which we are now operating, I have maintained for the past 22 years that is a rotten egg. And we cannot make any headway on this Constitution. I've just told you these 12 two-thirds. Now we have 37 two-thirds, which you cannot get. And maybe the next election, that issue will arise again. Let us sit down and change this Constitution. Allow the states to develop. Allow the federal government to reduce its powers and give it back to the states so that Nigeria can develop. We cannot develop on this Constitution we are running. My advice is that whoever comes into power in Nigeria, the first thing he should do is to revisit the 1999 Constitution. Call a conference. When Jonathan did it, I advised that the failure of Jonathan to have a legal basis upon which the commission he called could be is to create a legal basis where the result from that is a panel could go and people will talk about it, and then this House will pass it. But no, wasted Nigeria's money. The result came out, but today we have not seen anything. We need to change our system of governance. It's too expensive. All monies realized in Nigeria today goes to operate government agencies, goes to operate the executive, goes to operate the legislature. We Mekunus, we don't see anything for capital project. We don't see. Let us sit down, reduce our public expenses, allow the states to grow up very well, and let our leaders be disciplined in managing the affairs of the state. These are problems there, but God will give Nigeria a leader that will change the system. 1999 Constitution is our greatest enemy. It is rotten egg, and we cannot benefit from it. I'm not a seer, but I can assure you that nothing good can come from the 1999 Constitution. Thank you.
Well, on that note, I would like to thank you very much, Chief Robert Clark, Senior Advocate of Nigeria, lawyer and elder statesman. Thank you very much for joining us.